that is that I first had in that office. And the controversy around that has never died. Fast forward, we have a very notorious case involving Kenya, which is called the Kenya Duty Free. You have to read it to believe it. Contracts were handed out of that, and Kenya was hauled before an ICSID tribunal. When Kenya went there, it was able to make a very good case to demonstrate that these leases had been corruptly obtained, and the ICSID tribunal dismissed the claim. You would have thought that would be the end of the matter. No. The claimants returned to Kenya, filed a claim in the High Court of Kenya, and demanded the same amount that they had lost in ICSID. Notwithstanding that the ICSID tribunal, in very colorful language, and I challenge you to read the award yourself, had described in great detail the bribery and corruption allegations. So this went to an arbitrator, believe it or not, a former judge, as senior as you can get, and their judge gave an award, a substantial award to the claimants. It is when they got to the High Court to enforce the award that Kenya then raised the issue of public policy. So here in our jurisdiction, the resistance to the enforcement of most of these awards is a public policy. And they say that corruptly obtained leases are unenforceable and would be unenforceable as against public policy. And the judge agreed, and the award was dismissed. So that's the kind of experience we've had. I know that our neighbors have also had situations where what is sought to be attached is the national aircraft. And I know that that has happened on 1 or 2 occasions, which they are turning the national government to the table to negotiate. And that's our experience.
Thank you very much. It was a very interesting and enlightening perspective. Maybe for contrast with South Africa, Michelle, do you have any comments on this?
I'm happy to offer some perspectives, but I think at the outset, maybe just a high-level view, which is that there's really very little, certainly in my world, very little academic or scientific about enforcing foreign arbitral awards against sovereigns. Typically us lawyers find comfort, with large repositories of case law, but in this area, you actually just need a little bit of cunning and to sort of paint some broad picture or some broad background is really that, the rules of state succession, unlike, with individuals or with private entities, the rules of state succession ensure that states never disappear and they can't discharge their debts in bankruptcy, right? And so the rules of state succession provide award creditors with some sort of quite powerful, or they preserve at least their entitlement, through sometimes some quite drastic internal changes in political order. So the good news is that you are likely to get paid, but commercial assets are fair game. And of course, what is and what is not a sovereign function is its own kind of thesis, really. And of course, states argue all the time that everything is a sort of sovereign asset. Every asset is exercising a public function. If it's oil royalties or if it's airline royalties, all of those are immune and immunity attaches. But I suppose your job then is proving commercial activity, and typically, how do you do that? Well, I suppose the traditional test is, if a private sector actor could substitute, well then, it's typically classified as something which is a commercial activity, and it's fair game. Immunity doesn't attach. I think a caveat there is obviously central bank assets. So central bank assets are the subject of their own kind of category of immunity under international law. There's obvious policy reasons, I think, for that. Also interesting is sort of sovereign wealth funds. So sovereign wealth funds are typically structured, it's quite difficult to attack assets held by sovereign wealth funds because they are sort of structured in a way to benefit from immunity, and their mandate is often intertwined with that of the central bank. Typically their foundational principles are also to execute on fiscal monetary policy, so that immunity might attach on various layers. So I suppose now we've established that this is a commercial sort of asset, and then the question is, well, how do we get our hands on it? And I think there are a couple considerations there. I mean, ideally you attach assets which vest directly in the state. But of course we know that in practice, assets, commercial, sort of bankrolled by Treasury, those tend to be the kind of two extremes that one sort of considers when one looks at sort of degrees of separation in terms of attaching SOE assets. I mean, the last point is really on this, is that there is often also specific in-country legislation which protects national key point assets. South Africa has legislation which shields the state from attachment of sort of specific power stations, etc. That's obviously a neat legislative solution. So, the state doesn't have to worry about making arguments around, sovereign immunity and whether it attaches or not. Ultimately, there's a legislative solution. And the other bit, which is, I think, quite topical on the continent, is, of course, the benefit with attaching or chasing assets held in an SOE is that often, you can threaten a winding up petition. And there's nothing to focus the mind quite like a winding up petition brought against an oil SOE or your national airline, to sort of focus the mind and try and lever payment. So that's definitely been used in South Africa to try and prompt payment of debts owed by SOEs. Yeah. I mean, I think, the other point on sort of dealing with sovereigns is this notion of kind of, it's definitely another trick in the bucket, but it's this notion of sort of perpetually defaulting in proceedings, right? So, whether it's strategic, a strategic silence, or whether it's, potentially negligent or as a result of mismanagement. We see that a lot, where states, in the face of arbitral proceedings or enforcement actions, are silent and do very little. And there's a really sort of important case in point in certainly in our part of the world, which is the case of Lesotho versus Fraser Solar. And this dynamic played out there, pretty on point. I think Fraser Solar notified Lesotho about 25 times of an arbitration which it had bought. And of course, Lesotho does nothing. Ultimately, Fraser Solar takes I think it's a $50 million or €50 million award in default. Lesotho government does nothing. Fraser Solar decides to bring recognition proceedings in South Africa, and Lesotho does nothing. Then Fraser Solar decides to attach assets. And I think there were 5 different enforcement proceedings brought, in that case, attaching water royalties. And of course, now everyone's awake, right? And then what you see typically is all these sort of quite bureaucratic red tape arguments brought sort of 10 years after the time, trying to unravel the sequence of events, saying things like the original arbitration agreement and the original agreement concluded between the state and Fraser Solar was non-compliant with Lesotho procurement laws and therefore invalid. Other sort of related arguments saying that the request for arbitration had been filed against or at the wrong government address or wrong government entity. And so you see all these kind of quite procedural, technical arguments play out, and I think that's really common. And maybe just one sort of last point on that is really the public sympathy factor. You know, that's very real when you are executing against sovereigns. By and large, the state's debts, and in particular sort of arbitral awards, are satisfied by taxpayer funds. And so it's quite common where a state is being recalcitrant, where a state is avoiding or delaying payment, for constituents within that jurisdiction maybe to meet that recalcitrance with sympathy or even support, and even to justify it in ideological terms, right? You know, because obviously it has a huge impact on the fiscus. And I mean, a case in point there, which a lot of you will be familiar with, is Teche Copper in Pakistan. I mean, that was a $6 billion exit award taken against Pakistan some years ago now. Ultimately, it was a very controversial award, but ultimately it was the same value as Pakistan's entire health budget for that specific year. And so it was very, very controversial, and that in turn sort of has spurred a lot of the reforms in terms of, you know, UNCITRAL Working Group 3 and all the initiatives underway to reform the traditional rules of investment law. But certainly ensuring that you're on the right side of public sentiment, you know, ensuring that you've bedded down and have a strategy in terms of reputational concerns that might arise is crucially important.
Thank you very much, Michelle, for that detailed landscape. And I think it's a very good transition to my next question, which is more focused on the legal, maybe the more technical aspects of the enforcement process. And I apologize, it's a bit of a difficult question after we all enjoyed a nice lunch, but it's an important one. So maybe Adiola, can you tell us about what, in your view, are the main procedural and substantive considerations to keep in mind from that legal perspective?
So for the substantive consideration, I think is to start from the beginning. So you don't wait till an award has been delivered before. I mean, if from the beginning a party is entering into a contract with a state as with a state on the other side, it's very important from the beginning to get the drafting rights right. So the very first thing is ensure that, of course, if the dispute is to be resolved by arbitration, ensure, just like I had mentioned earlier, that is an express waiver by the government in terms of sovereign immunity. Because again, you don't want to get into argument after a dispute has arisen as to whether the fact that the state entity has agreed to arbitrate, whether that, you know, whether that is an implied waiver of sovereign immunity. In some jurisdictions, the courts would interpret that a state having agreed to an arbitration agreement from the start means that the state is ready to submit to arbitration. Whereas some jurisdictions are very restrictive, even if there's an arbitration agreement in the agreement, they will still insist, and Nigeria is one of those jurisdictions, insist that the arbitration agreement alone does not suffice. There must be an express waiver of sovereign immunity by the state entity in the agreement. So from the start, you ensure that that is in place. And of course, when we're talking about sovereign immunity, just like I'd mentioned earlier, it's not just about the, just looking at it from the jurisdiction point of view alone. You also want to be, you also want to make sure that even when it comes to enforcement, that again, there's an express provision in the agreement that says the state is willing to waive its sovereign immunity when it comes to enforcement of, when it comes to its assets. Of course, again, you get into conversations such as, even if you have that express waiver in the agreement saying that the state is willing to waive sovereign immunity when it comes to execution, as to what does that even mean? Does it mean that you can go against the assets that are used for that are not used for commercial purposes? Of course, again, except there's an express provision saying that you can move against assets that are used for non-commercial purposes. It means even if the state gives you a waiver as to execution, what it simply means is that you can proceed against assets that are used for commercial purposes. So for me, it's very important from the start to have those express waivers, right? So when you then move from that, in terms of procedural, I don't think you start to think about that until a dispute has arisen. Because of course, at the beginning, when an investor is getting into a contract with the state as the counterparty, or if the investor is lucky, they're investing in a state where the state and their own home state has a bilateral investment treaty. Nobody really thinks about dispute, right? You think everything is going to go on well. In fact, at the time, the counterparty is interested in getting the contracts because, of course, there's so many people, you know, who are interested in such contracts and what have you. But after skipping the stage of having had a contract or having had an investment, having looked at the investment climate and you think it's a country that you can invest in and all of that, and then there's a dispute, and then the claimant then decides to submit a request for arbitration. I think at that stage, you then begin to think about the procedural considerations, because what it then means is that there's a possibility of an award at the end of the day. And if you have the award, there's the possibility, in most cases, that the state will not comply with the award, in which case you then have to move to the enforcement stage. So at the time when the claimant is issuing the request for arbitration, they then start to think about, you know, maybe engaging any early on. I mean, it may look like an overkill because it's like one is preempting already. First, it means the claimant is preempting that he's going to win the case. And then secondly, also means the claimant is also preempting that when it wins the case, the government is not going to voluntarily comply with the award. But I think at that stage, you can then, you know, start to, you know, speak to companies that, you know, that do asset tracing. You know, you start to look at jurisdictions where the state defendant has assets. You know, once those jurisdictions have been identified, again, you want to be sure what sort of assets are this. Are these assets that are being used for commercial purposes, or are these assets that are being used for public purposes? If those assets are assets that are being used for commercial purposes and express waivers have been obtained initially and all of that, you also want to be sure if there are any other procedural. You also want to then, you know, drill down to okay, looking at the jurisdiction that the state has assets. Let's say the state has assets in, say, 10 jurisdictions, for instance. You want to be very sure what the arbitration regime is in that state. Is the state a party to the New York Convention, in which case, when you're enforcing, you know that the grounds for resisting enforcement are limited. You know, if you're going to be enforcing things like interest, you want to be sure that even if the state has assets in a Muslim country, for instance, I know in Saudi Arabia, for instance, that you can't enforce. I mean, interest is not something that you can enforce. It's contrary to public policy, right? So again, even if the state has assets in a country like that, you want to be sure that, okay, the only thing that you can probably enforce is the principal and not the interest. So, I mean, all of this requires, you know, sitting down with asset companies, you know, to identify where the assets are, sitting down with lawyers to also identify that even if there are assets in those countries and even if they're commercial assets, you know, what are the arbitration laws like, you know, in terms of resisting enforcement? Is there any ground, you know, I mean, if you're going to go to a particular state, you have to be very sure that the resistance, the manner in which the award can be resisted is going to be very limited. So I think those are some of the procedural issues. For instance, again, if you were to enforce in a country like Nigeria, for instance, one of the procedural issues that you probably encounter is the fact that there's this requirement to obtain the consent of the Attorney General, right, when you're trying to move against the assets of the government, whether be it the Attorney General of the Federation or the Attorney General of a state. And of course, in practice, even though, of course, the principle surrounding that provision is to ensure fiscal responsibility, to be sure that the assets of the government are not just being used to settle judgments indiscriminately and all of that. But what happens is that in practice, the Attorney General is not going to give its consent. And even if he or she is going to give consent, it's going to be delayed. So of course, you know that in a country like Nigeria, that's like an additional burden, right, to get Attorney General's consent. And of course, even if the Attorney General consent is not given, there's a procedure where you go to court and then you can get an order of mandamus against the Attorney General to give the consent. But again, that brings in another layer of court proceedings. So these are some of the things that you have to really think about and drill down to that. In terms of procedure, you want to be sure, again, some of the things that you also want to look at is service, right? Service is easier in some jurisdictions than other jurisdictions. So I guess the key point, and to summarize, is that from the procedural standpoint, you want to go to a country where the procedure is a bit more fairly straightforward, provided that you've sorted out things properly from the substantive area, so that when you're then getting to the procedure, you're not having to meet up with so many procedural orders. But of course, this will be country specific, so you probably need lawyers in the jurisdiction where the assets are to understand what the procedural orders are, and then determine which of those countries is the best for you to proceed against the states. Yeah.
Thank you very much. And it's true that these procedural considerations can be extremely important. Ibrahim, any reactions from your perspective?
Thank you, Lucas. So Adiola talked about sovereign immunity and all that. So I'm going to talk about something different a little bit, which is if we have a commercial arbitration, it's not an investment arbitration. It's a commercial arbitration, and it is between the state and a contractor, for example. So are there any things that you should be on the lookout if you have the seat in Cairo or in Egypt? The main important thing first is to determine whether this contract will be considered as an administrative contract or not. If it is considered as an administrative contract, which has some conditions, first it has to be with a public entity or a state-owned entity or something like that, and it has to serve a public utility, and the contract has to have some onerous conditions, like it's not a balanced negotiation. There are some conditions that have been imposed by the government due to the special nature of the agreement. So if we have an administrative contract, there has been a very early amendment of the Egyptian arbitration law, which requires that you get a ministerial approval for that arbitration agreement once it is signed. So you need to have the minister in charge or his delegate, if it is an entity that doesn't have a minister, they have to approve that arbitration agreement. And that amendment, so the arbitration law was enacted in 1994, that amendment came into 1997. And since then, it has been a big debate on this requirement, whether it is a public policy issue or not. So there are lots of issues that surrounds this requirement that I'm going to talk about. So first, let's imagine this scenario. You have the contract signed by the minister, and the minister attends the ceremony signing, but there's no separate, ministerial approval, that approves the arbitration agreement in particular. Would that suffice or not? So that's one scenario. Another scenario is, what if the minister didn't sign, but he attended the ceremony of the signing? And that specific scenario has been brought before the Egyptian courts, and it's still tricky to know like whether that considered as an implied, approval or not. And it's very tricky because you have the pictures and you have the news everywhere. Another thing is it the liability of me as a contractor, or is it the responsibility of the administrative entity to get that approval? I remember we were in a big renewable energy project, and it was a big hassle to get that approval, and the financiers were very aware of that, and they were very worried about that, and they didn't want to have any signing done until they get that specific approval. And it took, I think, 2 or 3 months to get that. So another scenario that has been talked about before the courts, what if the agreement has been proposed by the administrative entity? That agreement actually contains an arbitration clause. Would that be considered enough? Like, can we apply the estoppel principle where we can say like you cannot like act in a way that defeats your own original way? So that's also another scenario. So there's a lots of things that have been talked about. And the last thing that has been very interesting, and it relates to your jurisdiction, which enforces annulled awards. So what if the award get annulled in Egypt because it's seated in Egypt? Would that be considered as an international public policy that denies the enforcement in France? Apparently France is more like, pro-arbitration enforcement, even if it is annulled elsewhere. So that's also another thing that you need to think about. Like, do we need to go elsewhere to enforce the award and forget about the Egyptian courts with the annulment proceedings and just go and enforce it in France, for example? So these are lots of questions. And we had several court decisions on that. One of them was a very notorious award called Malicorp Award. And in that case, there was a ministerial approval that was missing. The award actually got annulled, but for another reason, which is that the award was issued by a truncated arbitral tribunal, and this is considered invalid under Egyptian law. So me analyzing this court decision, I was saying like, this annulment is different than the other annulment. So if you annul the arbitral award for that reason, you have to go to arbitration again. But if you annul it for invalidity of the arbitration agreement because it didn't get the ministerial approval, then you go to courts. You cannot go to arbitration again. So that's why it was tricky to see like how the Egyptian court dealt with that. It seemed as if they were trying to maneuver this issue and to say we're not going to deal whether it's a public policy issue or not. It's anyway annulled. Another court decision, but it was issued by the Cairo Court of Appeal, and it was talking about this specifically, that the Egyptian government has to act in good faith. If you are the one proposing the agreement with the arbitration clause into it, you cannot go ahead and try to deny the enforcement or ask for the annulment because you didn't give the ministerial approval. It doesn't make sense. And also it was talking about estoppel principle, and it was talking about this particular decision. In this particular decision, what happened is that it was a concession agreement, and the concession agreement was approved by virtue of a law. So they said that law is much more important or has a higher level than the ministerial approval. So it's already approved by the government. It doesn't need an additional approval. So this is just a theoretical thing. And they actually refused the annulment of the award in that case. So this is a very important thing, and this is one of the things that also we find a lot in public projects, that there's always this we got asked several times about the validity of the arbitration agreement when it is missing that ministerial approval. And there's a lot of debate whether it's a domestic public policy or international public policy, who should get it, is it our liability or their liability? And when we talk about projects that are millions and millions of dollars and they can be defeated by this very tiny approval, it sort of seems inhibiting to foreign investment to come to Egypt. So I hope that they remove that requirement, and they stay ahead with the Supreme Council that reviews the arbitration agreements beforehand. And this is your responsibility. It's not my responsibility as a contractor to go fetch for this approval. So that's my 2 cents on this issue.
Thank you very much, Ibrahim. And your point about the distinction between administrative and private contracts is very interesting. It also exists in France, and it's true that it has a massive impact on the legal regime applicable to the contracts, including when it comes to enforcement. Maybe changing topics, so we've looked at some of the substantive questions. If we focus on the more practical aspects, what are some considerations and some advice maybe that we can share with the audience? Do you have any views on this, Michelle?
So I'll also try not to repeat some of the themes that have emerged, but I want to talk for a little bit first about credit ratings and creditworthiness, because states are typically very concerned to be able to access affordable capital. And so this is a huge consideration, a huge driver, and a huge soft lever in looking to get paid. We live in a very interconnected global economy, and states generally are terrified that if they don't pay their awards, it might disrupt their access to international capital markets or the like. They might be afraid, for example, that if they don't pay an exit award, they might compromise their reputation with the World Bank or other multilateral lenders. So this notion of creditworthiness is something, and credit reputation is something which is a huge lever in seeking to get paid. And we have a great war story on that. The law firm I was previously with, we took, it was about 10 years ago now, but we took an arbitral award against the government of Gabon. It was a commercial arbitral award, and of course, where do you try to enforce a arbitral award against the Gabonese government, not Gabon at that stage? Its judicial impartiality ratings were not very high, and so we had to, of course, then go on the hunt for assets, and ultimately we managed to ascertain through some very good asset tracing services that there was a escrow account in the London office of Citibank, where royalties to bondholders, Gabonese bondholders, were paid into an escrow clearing account, and they were only there for about 48 hours before they were unpaid to bondholders overseas. So we bought an enforcement application, we had the award recognized, and ultimately we successfully managed to attach assets in that 48-hour window. And risking a sovereign default, of course, that created a huge incentive for the Gabonese government to EFT pretty promptly, including all interest. So that's another, I think, a really good example of how sort of credit ratings can be sort of really an important element in your strategy in terms of getting paid. The other issues that have been touched on, I mean, the sort of bureaucratic bits, I think, are also very real when you're litigating, arbitrating, enforcing against states. States typically move very slowly. There's a lot of red tape to try and get settlements over the line. Typically, officials, in my experience, don't sort of like to take a view. There's a lot of potential political capital on the line. They don't want to sort of compromise their positions, so ultimately it's often easier to do nothing. And as a result, I think there is a phenomenon where, proceedings against states do kind of proceed longer into proceedings, and particularly do kind of enter enforcement phase because of this sort of very real dynamic. And the converse can also be true, though, because where you have new regime officials, they might actually be quite happy to engage in a settlement relative to a prior regime's debts. There are no political pain points for them in doing that, and ultimately they might sort of be seen to be responsible, etc., in relation to those debts. So that is the sort of bureaucratic point is definitely a real one in dealing with states. The other interesting point, which I just wanted to mention, which is very brief, is that we've actually seen quite a nascent market for the sale of arbitral awards against sovereigns. It's a very sort of real dynamic. We were chatting to funders the other day about this exact issue. And when I say sale of arbitral awards, I don't necessarily mean an outright sale of the proceeds of the award. You know, there's some quite elaborate, interesting structures. And so, you know, one option might be that a third-party funder will fund litigation in return, for example, for a portion of anything that's recovered. So those kinds of you know, mechanisms and structures are increasingly being agreed. And then I think the last point is this point on public policy, which we've discussed sort of at length. Of course, arbitral awards are supposed to be final, but you know, and I'm talking about international commercial arbitral awards. They're supposed to be final, but of course, in most legislative frameworks, and this is just for the benefit of those who aren't sort of lawyers in this room, I know there are a lot of engineers, and you know, arbitral awards are supposed to be final, but there is a valve built into that finality in most modern arbitral frameworks, which says that, you know, and in this case, if the arbitral award offends the public policy of the jurisdiction that is seeking enforcement or recognition, ultimately, you know, enforcement may be refused. And so public policy is a very common basis for recalcitrant respondents to try to, you know, defeat enforcement proceedings in relation to arbitral awards in particular. So we see this public policy exception, this old chestnut, it's often rolled out. And in our experience, parties argue almost anything under this concept of public policy to try to avoid payment. The arguments get extremely, extremely creative. And unfortunately, my lived experience on the continent is that typically where you have arbitration, often you have satellite litigation on the back end. And this is a case in point. We took an arbitral award in South Africa, a South African arbitral award for a mining client a couple years ago. And we then decided to go to Zimbabwe, the Harare High Court, to enforce. And this remains one of the more bizarre days of my career, but we were faced with the argument by the other side. We're obviously trying to recognize and enforce this award. The other side, of course, raises the public policy exception and defense and says, the argument went like this: the South African arbitral award you are trying to enforce is bad in law. They don't agree with it. Mind you, it was penned by one of the most senior South African councils, but that's a side note. The arbitral award is bad in law. It's against Zimbabwean public policy for arbitrators to get the law wrong. And so, so there's no way that the Harare High Court can enforce this arbitral award. And so those are the kinds of arguments you face. And that morning, actually, as a side note, we were in the same court. It was the morning session. And the judge unilaterally, and this wasn't even pleaded, asked whether he had jurisdiction to set the award aside. At this point, we are kind of having raised eyebrows. And the reality is that in those situations, you have to kind of deal with it. Ultimately, we had to explain to him, no, you know, this is a South African seated award. You have no jurisdiction to unilaterally set aside the award. You know, and that, you know, also this issue isn't pleaded, so you cannot unilaterally assume jurisdiction and set aside an award where, you know, ultimately you're only at liberty to refuse enforcement. So that was another pretty bizarre moment. But you know, as we've discussed, fact is often stranger than fiction, and you kind of, the reality is that you have to deal with these situations. And if the award had been set aside, it creates a massive headache in other jurisdictions, right? So these are all very real kind of lived risks and experiences on the continent. But I will leave that there.
Thank you very much, Michelle. Professor, any practical advice or reactions for our audience?
Well, I thought I would say something about, I was sharing with my colleagues before we started the panel, that the one thing I learned from American lawyers is that only a very poor lawyer tries a case he can settle. I have found that if you have an award against a government, you must try to incentivize the government to a settlement. And one of the things that I have found works quite well is by agreeing to negotiate the award itself. I know that is, it's almost goes against a lawyer's basic logic. I have my award, it's been given by a competent tribunal, why should I be negotiating it again? For very good reason. You cut the lead time. And I found that I have been involved in a number of ICSID review committees, and I have found that most governments in our continent go to the review process to buy time. To buy time first and foremost, because all these awards are very controversial at home. They buy time to get public opinion behind them. Like I told you of my own personal experience with the Anglo leasing cases, it is very, very hot politically. So you need a lead time to bring the public behind you to be able to settle an award. And lawyers need to know that and to appreciate that.
Thank you very much. And I will go against my lawyer instinct and tell you that it's a very good advice. I'm mindful of the time here, so oh, sorry, please.
So if I could just quickly add on the strategy point, I think one thing that was very clear to me in the Zhongshan case that I referred to earlier is the fact that, publicizing these things themselves, could create some sort of fear in government quarters, right? So for Zhongshan, for instance, they had, I believe that going against the presidential jets was a strategy. They knew they were not going to, because what they had done was they got interim attachment, they got the attachment on an interim basis in the first instance, knowing that, of course, once Nigeria becomes aware of that interim attachment, Nigeria is then going to oppose the attachment. I believe that in going against presidential jets, they knew that those assets were not for commercial purposes. They knew that it was for public purposes, but deliberately pursued it in any event so as to create some sort of publicity for the award that they have in their hands, and several years after, they haven't been able to enforce the award. Because what then happened was, as soon as the Paris courts, gave the interim order attaching the presidential jets, what happened was that it was everywhere in the news, it was in Nigeria, people were even making memes about it and all of that, 2 jets have been, or was it 3 jets, I can't remember now, have been attached and all of that. And I think what that then did for the plaintiff in that case was that even though Nigeria had then issued a circular, there was a public circular to say, oh, these are, yes, we are aware of this award. In fact, the award was not even directly against us. It was against some other governments and all of that, but in terms of going after presidential jets, clearly you can't do that because it's not for, these jets are not being used for commercial purposes. But as it stands, and of course, this was last year, you have a government who just came into government. The current government came into government in 2023. Of course, you had the PI&D case as well, which was also very publicized. You had this very huge award against Nigeria as well. So I think looking at all of that, the people in the government then had to sit down and talk to themselves that even if they had like a legal defense to this whole commercial assets or public assets or whatever it is, it was very important for them to settle that case. And what you have in this case is that eventually they called the claimant to the table and they're trying to find some sort of resolution for the award as far as I'm aware. So I guess for me, the key point from that case is that sometimes, public relations can help and, making some sort of noise about the award, and depending on the timing as well, this can help in bringing the government to the table to have a sit down with the award creditor. Yeah.
Thank you very much, Adiola. So we're running a bit over time, and I'd like to leave some time for questions from the audience. So maybe one last question to you, Professor. Looking at the future, what are some changes that you would like to see implemented in the continent?
Well, first, I would like to see more involvement in the tribunals that hear African disputes of Africans. I think this is, the time has come, and there isn't like anything like the urgency of now. It is totally unacceptable, in my opinion, that disputes relating to the continent are resolved far from the continent using 90% of the actors are not from the continent. That is not going to be sustainable. And that is what I would like us to have a dialogue about. That dialogue must begin now so that tribunals begin to reflect the nature of the conflict before them, the dispute before them. That's one. Two, Africa is moving in the wrong direction in terms of arbitration institutions. We don't need more, we need fewer. At the last count, I think we had 90. We don't need 90. We need one strong institution in Southern Africa, a very, very strong one in Eastern Africa, including Mauritius, very strong one in West Africa, and a very strong one in North Africa. And then we can capacitate them to the same levels as European arbitration centers. And that will take us in the right direction.
Thank you very much. And you've given us a lot to think about. So I think that this brings us to the end of the moderated part of the discussion. Thank you very much to our speakers for the very insightful comments. Please give them a round of applause before we move to questions. And yes, happy to take any questions from the floor. I think we have one over there.
First of all, just to the professor, just thank you for the last comments that you made. Could not agree more. I think it's absolutely what Africa needs. A solution of African problems by Africans has to be the way forward. So great to hear that said. And then a quick question just for Michelle. If you look at the South African courts at the moment, do you think there's a clear policy position with regards to review of arbitration awards? Is it a crystallized position, or is it still a depending on which judge you get on which day?
This is one of my favorite topics, and I'll try and keep my views brief. So, on paper, the South African judiciary is very pro-arbitration. We have some fantastic, particularly in our higher courts, our apex courts, so Supreme Court of Appeal, Constitutional Court. We have watertight, pro-arbitration, judicially supportive, on commercial trials at the moment for 2032. So there's a lot to be done. And as a result, there's been an introduction of mandatory mediation, which has been very controversial. Matters are about to be essentially unenrolled pending an ability to furnish a mediator's report. At which point they can then be set down. That has now recently gone on urgent petition to the Constitutional Court, but that is very much a separate issue. I think at High Court level, so all these difficulties aside, at High Court level, the issue for me is one of consistency. And when you're building a seat, it's consistency of precedent which matters. And so I always argue that a system, a seat, the safety of a seat rises or falls to the extent of the quality and consistency of your high court level decisions, because the reality is that parties don't have the time or cost inclination to go all the way to the Supreme Court of Appeal and the Constitutional Court every time they want to enforce an award. And at High Court level, it is still very patchy. I'm very patriotic, but can I, with my hand on my heart, advise my client to agree a South African seat? I feel conflicted because I owe my client a duty of skill and care, and ultimately it's an uncomfortable discussion I have to have with myself. You know, because for every brilliant decision that comes out the South African High Court, and there are lots of them, there's an absolute clangor. There was, a couple months ago, we had one, a finding of gross procedural negligence on an absolute whim, and it becomes very difficult in that uncertain environment to advise clients. So, you know, that is my view. The other issue with South Africa as a seat is that there are so many recalcitrant practitioners around, and my firm view is that practitioners need to appreciate that they can do damage to the institution of arbitration in terms of their conduct. You know, we have so many examples of, you know, parties using arbitration for free credit. You know, those kinds of things, and where you've got a trial set down for 2032, ultimately it's an environment that facilitates that kind of approach. But absolutely, I think South Africa is promising. It has good precedent, but I think there are some real practical difficulties which detract from its competitiveness as a seat.
Any other questions? Yes, sir.
Good afternoon. Thank you very much. I'd just like to take it from the issue around enforcement. You spoke about public policy as one of those challenges that we encounter in the aspects of enforcement. Now, someone from, I think, Zambia mentioned in the morning, and I do agree with him, can we find a scenario of sifting through an approval or leave process? What goes into the court for the purpose of a review to set aside an award? Maybe it can also be considered that the possibility of having some sort of security or deposit in favor of that award as a condition for you to even approach the court for the purpose of setting aside an award. I think if we begin to look in this direction, the possibilities around setting aside the enforcement process will be narrower. Thank you.
That's a very interesting idea. Does anyone want to react? Any comments?
So the definition of public policy has been a variable issue across the years. It has been developing over the years. Like in some instances it was very narrow, and in other instances it was quite broad. So what you're saying about depositing some sort of a security for costs against like anyone like trying to set aside an award is a good example of like innovations that can be done to progress arbitration and make sure that not everyone tries and annul an award just for any frivolous reason they might have. And especially like this is something that is usually abused in countries where the court fees are minimal, so it doesn't affect you like to like file an annulment case. It's not going to cost you anything, so why not like prolong the process as much as possible and make sure that the award creditor doesn't get the money on time. Another thing is that I think needs more development is the ability to get interim measures at the start of the arbitral award. So we're facing a lot of like problems with that in Egypt specifically. I don't know about other African countries, but it's not easy to get like an attachment or a freezing of a preservatory attachment of assets before the arbitral award is issued. And everyone is afraid that, you know, someone will dissipate the assets, you know, before the arbitral award is issued, and you have an award, but you don't have any money to collect or to enforce against. So I think there's some issues that need to be done within all parts of Africa. One of them is your suggestion, and there's other suggestions as well, in my opinion. Yeah.
And maybe one additional comment on this, because it's true that even with these very good ideas, this never completely eliminates, litigation or all these issues. I think one interesting example is in construction projects, the issue with performance bonds. Even when you have unconditional, irrevocable letters of credit or other instruments, there's always a lot of litigation around those. So that goes to show that even with the best intentions and the best mechanisms, there's always, especially when you reach that enforcement stage, those judicial and other litigation issues. Any other questions? Yes, we have one over there.
I go first. So 2 last ones. Can I go? Good afternoon. My name is Robert Mwangi, G&A Advocates, LLP. I think I have 2 questions. Let me first raise to Adiola. You did speak extensively on incorporating certain clauses, and you call them waivers, waive sovereign immunity, waive this, waive that into the contract. Aren't you contracting yourself into a dispute when you take that path? And would the sovereign be apprehensive when you insist on such kind of waivers, even before we have entered into these contract? The next question, I would maybe address it to Prof. It's in relation to how would we address the risk of regime change when it comes to enforcement of the awards, because like the scenario given, the Anglo leasing happened in a different regime, but the new regime was a little bit sympathetic because the timing was ripe. It needed a Eurobond, and that is why it was settled. Were it not for that, I do not believe it would have been satisfied. So how then would we cater for such a risk, in that there could be a time when we are in favor with this regime, but then in case of a dispute, we are in a different regime altogether, and then questions of public policy arise, and then we are unable to enforce. Thank you.
Okay, thank you for your question. I think from a risk management point of view, yes, you're entering into a contract, you're very happy that you've even been awarded this contract out of all, from all other bidders and all of that. So of course you're trying to be careful and everything. But from a risk perspective point of view, I think the best time to insert those sort of clauses are at the contracting stage. Because what happens is the moment a dispute comes up, there's no agreement on anything. And of course, even when the law implies some obligations on the part of the state, for instance, like I said, if a state had agreed to submit to arbitration, there's that implied, it's implied that the state would also submit to the jurisdiction of the tribunal, right? But of course, you can have, for instance, if you're in a jurisdiction where you don't have the law being very clear that you could make those sort of implication, you can spend another 10 years litigating whether, the court saying, oh, you can imply this is right, whether the court was right or whether the court was wrong. So for me, as a dispute practitioner, to avoid litigating and debating, spending 10 years litigating this and litigating that is very important from the beginning. And you may be very lucky. It states you can maybe sometimes squeeze these things in. Maybe it will be missed. If they're not missed, if they're being negotiated, you negotiate it. It's not like you're thinking that there's going to be a dispute or anything, but it's just better. It's better to be safe than sorry, to negotiate those things from the beginning rather than wait till when a dispute occurs and then you're in court litigating something that you could have agreed upon from the beginning. So that's the way I look at it.
Yeah, on the political risk question, I know lawyers like to have certainty about law, but we all know that it is impossible to have certainty about law, because not only are we talking about regime change as is happening in West Africa with the soldiers taking up some of the countries there, that is really critical regime change, and denouncing everything that had gone before, whether it's mining rights, development rights, construction rights, not even that. Just look at what is happening in America today. The constitution that President Trump is governing with is the same constitution and legal order that Obama governed with, or for that matter, Ronald Reagan. But the practical legal outcome is very different. So I'm afraid we cannot insure ourselves against political risk. We have to live with it and manage it.
I have a question here. Thank you. This goes to Prof. I've followed and I entirely agree with the submissions that you've made. I would just like to you share with us your experience. Not very many of us have had the benefit of sitting in that office of the Attorney General and being able to participate in approval or negotiation of contracts where we are binding our countries. I would just like to know what are some of the forces or interests that come at play. The reason why I'm saying this is by far and large, I think some of the contracts that personally I have happened to see, and some of them that have ended up in disputes. Sometimes disputes are not avoidable. However, the negotiation, I get to a conclusion that I believe that, and this is a continental issue, that when it comes to negotiation stage, entering into these contracts, it's as if, as African states, we have a weaker bargaining or negotiating power. My sister from Nigeria was giving that we need to include this, we need to include that in the contracts. It comes to negotiation, and then, for instance, where you're choosing, and I agree with the solutions that, Prof, that you've suggested. We need African-driven solutions for the challenges that we have, but it starts from the insertion into these contracts, the choice of law, the seat of the arbitration, which institution are we going for, and so on and so forth. So just help us understand what forces or interests in negotiating these agreements. Why is it that across the continent there are many of these poorly negotiated agreements that when it comes to enforcement, whether you've inherited it, whether you're the office bearer at that time, it becomes very difficult. And like my sister said, we now start to do everything within our powers to avoid paying. I think the solution is at the earlier stage of negotiation to try and mitigate or reduce these damages. Thank you.
Well, one of the critical problems that we face on our continent is that on the whole, we are net capital importers. And therefore, we are negotiating with capital exporters. And from the go-go, that's not a level playing field. So either you want the airport, or you want the seaport, or you want the road, or you don't want it. The person investing is the person who holds the upper hand. And when I was in government, we spent a lot of time fighting over choice of law, choice of forum, and so on and so forth. We did succeed to gain momentum on that Kenyan contracts can only be governed by Kenyan law. Yeah? I inherited some that were subject to English law, which was not disastrous because No, that's the parent legal system. As to the forum, that is an ongoing battle. When we set up the Nairobi International Arbitration Center, we then had a policy that said all disputes should be resolved within the center because the center accepts arbitrators from all over the world, and you can choose whoever you want. But my colleague here made one of a very profound point, which sometimes we in the industry don't appreciate. Your arbitration centers are as good as your commercial court. If your commercial court is inefficient or inept or corrupt, then you have no arbitration center. You have no arbitration forum. And that is something that we really ought to be very concerned about. Here in Kenya, after many years of uncertainty, the law has now been settled by the Supreme Court. Once an arbitral award is to be enforced, it can only be set aside on a very, very limited ground. And once the High Court dismisses the setting aside, there is no road to the Court of Appeal. It's a very small window, very, very small, that to get to the Court of Appeal, you really must show that the High Court has failed totally to. So my own view is that the tide is shifting, but it will never shift substantially, because even a big economy like South Africa or Nigeria or Egypt, which we hold in very high regard, they are more or less in the same shoes as the rest of us, because you either want the nuclear plant built or you can build it yourself. So from there, the person with the capital is the one who says, I don't feel comfortable entirely with having a dispute settled in this country, and so on. What we also started doing when I was there is to say, let us agree on a third-party alternative. How about Mauritius? And we made progress along those lines. So it's a conversation that is ongoing. I think everybody is concerned about what the status quo has thrown up, but we are not all very sure what is the alternative that works for the capital exporter and works for the capital importer, somewhere in the middle. Needless to say, every time a small country has to pack and go to Paris to spend a week, I'll give you an example. I acted for the Kenya government last year or the year before in my private capacity in a dispute involving a privatization of the Kenya Railway that went really belly up, totally belly up. And you find that if it were not the era of video conferencing and what have you, I would have been required to have about 40 witnesses in London living in whatever for 4 weeks. So a small country defending itself in a faraway place is exceedingly expensive. And for most of these African countries, you also need to have local counsel as you defend the claim, because it can go in any direction. And also it may be useful to have a lead counsel with certain kind of know-how. As we all know, as lawyers, it's not enough to be able to say, I know international investment law in general, because a specific, like the case I did, the testimony was from very, very technical people, locomotive engineers and so on and so forth. And I would find that it is very useful to have a lawyer in London who has that kind of engineering dispute know-how. So I think we'll get there one day. It's moving in the right direction. Thank you.
Perfect, and I think that's a perfect point to end there. And of course, we'll be happy to answer any other questions during the break if you have them. Thank you very much again to our speakers and to you, the audience.
Thank you so much, Lucas, and your panel for guiding us through that very fascinating conversation. And like you said, most of this panel will be available throughout the break, so you can catch them at that point. But at this stage, I'd like to invite you for a photograph. Do we have the camera? As is tradition. And while we do that, I'm really pleased to invite on stage Madam Ogongo Makinde, who is a partner at Aluko and Oyebode in Nigeria, to help me present plaques of appreciation to this wonderful panel. Wonderful, excellent. Round of applause to my panel. First up, I'd like to appreciate Mr. Lucas De Ferrari, partner at White & Case, Paris, France, for expertly running this session. Thank you so much, Lucas, for guiding us through that process. Thank you so much, Lucas. We'd also like to appreciate Professor Githu Muigai for sharing your experience at the State Law Office, but also just your insight on the matter. X marks the spot. Thank you so much, Professor. Let's appreciate Michelle Porter-Wright as well for being part of this. Michelle is a partner at Baker & McKenzie in South Africa. Thank you. Next, let's hear it for Adeola Agunbiade Adeyemi, who is a senior associate at Banu and Igodalo in Nigeria. Excellent. And finally, Ibrahim Shetata, who is a partner at Shetata & Partners from Cairo in Egypt. Round of applause to all the panelists, ladies and gentlemen, for that session. Thank you so much. So, ladies and gentlemen, we are almost bringing this to a landing. We have just one session to consider, but I've also been reminded to just share some quick updates. I know we have quite some delegates who will be flying out tonight, and so we'd like to expedite the dinner. So we will start at 7 o'clock promptly, so that we allow those who have flights tonight to be able to catch them. This dinner will be happening in this very room at 7 o'clock. So once we finish the session, you can take a quick break, but we'll be happy to receive you minutes before 7 so that we're able to start on time. So just please take note of that. Great, so best for last. Ladies and gentlemen, I'd like us to take part in one last conversation, and as we do that, we are jumping straight into it, but from time to time, if you do need to catch a break, you can bring your coffee and come back, but we are going express so that we're able to catch up with time. This session is session 7 on your programs, and we'll be looking at risk allocation in African construction, breaking the impasse. This is a conversation that will be chaired by Mr. Timothy Harwin, who is a partner at HKA South Africa. If I could invite Tim on stage to be able to take on this session. I'd also like to invite the panel joining Tim to, if you could just step up on stage as well, to be able to take part in this. Let's give them a round of applause as they come, as I hand over to Tim.
Somewhere in the middle here. So it looks like it's been quite a turbulent flight. Up here there's a few wounded soldiers, but yeah, so over to us as I think the best for last. So we'll do our best to wake you all up, get everybody to where they want to be, which is with drink in hand in about 90 minutes from now. So bear with us, and hopefully you might find something interesting from us over the next hour or so. As was just mentioned, we're going to touch on a subject which has been discussed in almost every session over the last 2 days, which is risk in all its forms on infrastructure projects. So we're going to sort of step through a few questions amongst our panelists here and see if there's some helpful insights that you can take away, and next time you're entering into a construction project, you've got some tools to use. I'm a partner at HKA in South Africa. I'm from an engineering background, and my focus area is in expert witness work, particularly delay and disruption on construction projects. As I said, most of my practice is in South Africa, but I've also worked on projects in Ghana and Botswana. I'm with Ogogo Makinde, who's a partner at Aluko and Oyobode in Nigeria. Ogogo is the head of the Business Advisory Unit and a key member of the firm's banking, project finance, energy and natural resources practices. Ogogo advises on high-value transactions in diverse sectors, including advising on financial arrangements for projects in oil and gas, healthcare, hotels, hospitality and manufacturing sectors, as well as Nigerian statutory and regulatory compliance matters, licensing permits and corporate government issues. So welcome, Ogogo. Next to Ogogo is Diogo Duarte de Campos, who is a partner at PLMJ in Lisbon in Portugal. Diogo heads the public law practice at PLMJ. He has more than 20 years of experience, particularly in the areas of administrative law, public contracts, which is quite important for today's discussion, public procurement and construction. His experience also includes litigation in state courts and arbitration, both as a lawyer and as an arbitrator. He has worked with clients in several countries in Africa, particularly Cape Verde, Angola, Mozambique and others, on a range of infrastructure projects, and he has experience in construction, transport, real estate, water and sanitation and energy sectors. Welcome, Diogo. On the far left here, we have John Woolley, who is a partner at Pinson Masons in the UK. John advises clients on transactions relating to energy, airports and highway projects, including 15 years on projects in Africa, including here in Kenya, Rwanda, Nigeria and some other African countries. John is fully engaged on the debate of how innovative technology has the ability to transform contract procurement and negotiation, as well as project delivery. Welcome, John. And last but not least, my fellow partner, Stefan Brill, who's part of our business in HKA South Africa. Stefan uses his contractual and commercial background to manage complex FIDIC and NEC and other contractual claims and dispute proceedings on multidisciplinary power generation projects particularly. He's worked in Europe and Asia before spending now a large portion of his career consulting and advising on projects in South Africa. So this is the best, and it's also the last. I think amongst us we've got a strong cross-section and hopefully with experience across the continent, but also across a variety of infrastructure sectors, including the full project life cycle from transactions and negotiations right through delivery and into disputes. And we're going to share our insights on how inappropriate risk allocation destroys project outcomes, and then with the solutions mindset, how can we develop balanced risk allocation frameworks and insights on innovative risk sharing structures. So the key word being risk, and as I said before, that word has popped up over the last 2 days in almost every session. I come from an engineering background, as I said, so risk to me, when someone mentions the word risk, I naturally think about technical issues that arise on projects, whether it be community unrest or design issues or inclement weather, or issues which affect progress in the delivery of projects. But that's, sorry, is that going in and out? No. But that's my perspective when I think about risk. We've also heard about payment and cash flow risks, corruption risks, risk of completing inadequate feasibility studies, which you heard about in session 2, including the risk of underestimation, physical risks such as groundwater, risk of being overly optimistic on your program, risk of cost overruns, revenue shortfalls, procurement risks, inexperienced contractors, and it doesn't stop there. Design risks, political risks, sovereign risks, currency risks, and risks in energy supply and connections. And yesterday evening, we even debated the risk of ineffective DABs, and just now, enforcement risk in arbitral awards. So wrap that all together, and it's very likely there's a risk of unfavourable circumstances arising on your project. It's the nature of the beast, as was said yesterday. So I don't know about all the delegates here, but it makes one wonder, why would you attempt to build anything at all? And you can also understand why owners and investors like to push as much of that risk onto other parties. So where do we start? Diogo, I'll go to you first. In your view, what is inappropriate risk allocation, and why does it persist, particularly in Africa?
Thank you for the invitation, for the introduction. So I would say that we have two different scenarios. The first one, it's contract drafting, and so contract negotiation, and then contract implementation. I think this is two different things. And I would say that the first problem concerns, of course, contract drafting, where there is a clear power imbalance between the employer and the contractor. Usually the employer has most of its power at this stage, and it uses more than it should, and transforms then some problems into the execution. I usually say, if we had a graphic, the most relevant day for an employer is the day before signing. If he asks anything to the contractor, most probably the contractor will say yes, if it is a big deal. And then its power starts to diminish, and the power of the contractor starts to rise and reaches its top some days or some weeks before practical conclusion, where if the contractor just says, okay, you are not doing what I want, I'm leaving. And, you know, then we'll find in court, but I'm leaving, and the infrastructure is as it is. You have to have a new tender to finalize this, and it's almost done. So this has two problems. When a power imbalance in contract negotiation leads always to disproportional risk allocation. The employer usually says the best way to do it is not to put the risk on the one that better manages it, but put everything in the contractor. And then there's also a problem on contract implementation, because the contractor gains more power, and there's also a mismatch here, usually between the technical capacity of the employer and the technical capacity of the contractor. Usually the contractor is much better arranged from a technical point of view than the employer. The contractor has done this 10 times, 20 times in 20 different countries. Most of the times the sponsor or the employer is the first one, so it makes that the contractor has more power to renegotiate many things. And this leads to unsatisfactory outcome, because this leads to actually the employer paying sometimes 2 times the same risk, because it will pay an overhead on the contract, because as he drafted it, putting all on the contractor, he will put an overhead, of course. But let's be honest, if it is a big risk and if it materializes, the contractor, which is technically more sophisticated, usually, he will try to litigate it and try to put it against the employer again. So he will pay twice, and he's paying the employer once again for risks that do not materialize at all, but they were paid because they were on the contractor side, and he had an overhead. So I think this is, broadly speaking, why there are so many mismatches between what it should be and what happens in reality. And I have seen this almost in every country. And to be honest, not only in Africa, also in Latin America or even in Europe, it's the same thing, to be quite honest.
Thanks. So Stefan, in your experience, I mean, what's the ramifications of getting the risk balance wrong?
Yeah, so... Hello? Yeah. Can I just get the presentation up? It's, I've got a few slides on that. So this is basically a presentation that I touched on last year when I was in this conference as well. But it is the 2024 edition, so it's the year after, and it's a reminder for those who were involved last year as to what the what novelties there are, as it's also a novel topic for those who weren't there. If we can get it up, that would be great. So basically, what it is, no, we're not quite there. Anyway, while they're working on it, it's based on an academic paper. Oh, we're going into Google.
I'm not sure that's the right document that I saw there. It should be a PowerPoint.
Do you want to swap perhaps with John?
Yeah, sure. No, we'll come back to you, Stefan. So John,
yeah.
I mean, construction contracts have been around a long time. They usually state that their purpose is to allocate risks appropriately, and there's, as most of the people in this room would be aware, there's contracts like FIDIC. Do you have any views on the use of those in Africa?
Thanks, Tim. Well, I've spent a long time doing FIDIC yellow and FIDIC silver in Africa. And I know we wanted to look at whether it's appropriate, because sometimes people feel as though FIDIC is being forced upon them. I think my first thought on that is it depends what we're trying to build. Certainly where we're looking at the larger, the higher value, the bespoke energy and infrastructure projects, one of the things we're concerned about is what's the capacity in the market to deliver these projects. And in relation to that, there's always some local capacity. There may be enough local capacity to deliver complicated energy and infrastructure, but very often you're looking to attract international contractors, often combined with local offering, in order to be able to deliver the project in question. And the reason I'm talking about that is international contractors are spread thin, actually. They often have many opportunities around the world, and one way, amongst many ways, in which you can attract them to this region is to say that you're going to contract on terms with which they're familiar or with which they're broadly familiar. And that's where FIDIC probably, definitely has the upper hand in international contracting across Middle East, CIS, Africa, Asia, less so in North America, but very much so in South America would be my brief global overview of FIDIC. But whichever form of contract you use, you're broadly still going to be talking about the same types of risks. In whichever part of the world you are, those categories of risks are going to be similar. But there may well be local, some very local aspects, regional aspects that need to be addressed in relation to those types of risks. So one thing FIDIC does do is, if you were to choose to use your local form here, you will find that, or choose to use a bespoke form here, say, you will find that everybody will be scrutinizing to a much greater degree in the contractor community what the risk allocation is that you've assigned. If you're using FIDIC, it's got an established risk allocation depending on which form you're used to, and the contractors will be used to pricing against that risk allocation and working against that risk allocation. So in a way, it's a means to an end. My job, to the horror of the FIDIC purists and people in the FIDIC conferences, is often to amend FIDIC, horror of horrors, to make changes to the FIDIC forms, and that's often necessary from a project-specific place. So using the standard form is often a shortcut to enable you to focus on the bits where the project cannot bear the standard form, where you need to change the standard form. So hopefully that's a useful perspective and a useful way to see it. Just going to quickly touch on project types, and then I'll hand back to Stefan. So just a sort of broad view, just running through the different types of project types we come across. So I'll start with PPP, and with a PPP, you've obviously got to have an EPC contract underneath your project agreement. Now again, there are PPP purists out there, and they would like to think they can insist upon a full back-to-back bespoke pass-down EPC that backs fully into the PPP project agreement. That is used sometimes in Africa. More often in Africa, we will use a FIDIC contract amended to reflect the requirements of the project agreement for PPP. Secondly, we've already talked about FIDIC as a form that can be used immediately, often on energy projects. And then there are also other local forms of construction contract. Now, I would say that they're more frequently used on real estate type development projects other than energy and infrastructure type development projects, and that's broadly a kind of split that you'll see. So ultimately, I just finish off by saying the standard forms are intended to be a cost saving, an enabler to everybody to get to the end more quickly than they would otherwise be able to do. and they're being recognised internationally, should be seen as being helpful for that. But yes, we spend a very, very long time negotiating the points that we have to change to get the specific projects across the line.
Thanks. Before we get to you, Stefan, I'm actually going to throw it to Agogo and just pick up on something that Diogo mentioned previously, which is around power imbalance in contract negotiations. Do you have any thoughts to share from your experience, particularly in Nigeria?
Good afternoon. Very nice to be here. Yes, a lot of firms experience. I'll look at the contracting and the power imbalance from two aspects. There is the public aspect and there is the private aspect. Now, when we look at the public sector contracts, the fact of the matter is the power is largely in the hands of the public sector, the public agency that is sponsoring the project. And for a number of reasons, they know the regulations, they have the backing of the government, they own the projects, and then you have a private sector party coming in maybe for a PPP or a service contract or an outright contract to try to develop a facility or to run a service. And from my experience, what we have seen is that in the last 10 to 15 years, there's been a lot of changes. In the past, it was quite clear. We all know the rules. Allocate the risk to the party that is most able to bear the risk. But more and more, we see a pushback by the public sector parties, even on traditionally public risk. So, for instance, the permitting risk, the regulatory risk, the risk of even data, the state of the infrastructure. We see more and more that the public sector party wants as much as possible to push those risks onto the private sector party, and this creates a form of imbalance, and we have long conversations and negotiations on how to ensure that risk is more properly balanced. The market is trying to correct for this because this project needs to be done. There's a lot of projects and a lot of needs in the different economies. And then when you layer on the Nigerian constitutional structure, we have a federal system where you have the federal government and then you have 36 states government and the federal capital territory. For the federal projects, those are owned by the federal government and its agencies. Contracting with the 36 state governments is like contracting with the subnationals. So it's like 36 different countries. They have their own laws, they have their own rules and regulations. And we see more and more that the state governments want to take on as little risk as possible. And in the last couple of years, as revenues have continually been challenging at the subnational level, the tribe has really had to push on a lot of the risk onto the public party, and so really that creates a lot of imbalance. So I'll give you an example. There are some state governments, for instance, the Lagos state, that have actually made changes to their laws where they prohibit state governments from providing support to projects. So they are unwilling to provide any guarantees. For the past 20 to 25 years, the federal government has totally exited the guarantee space. They would not issue guarantees in support of any projects, and because that was creating problems for the national debt and of course the World Bank negative pledge obligations. But we see that has now drilled down into the subnational level, and the state governments are unwilling to provide any form of financial or guarantee support to projects. Happily, and we'll discuss this later on, there's some credit guarantee companies that are coming in to try to de-risk these projects to at least ensure that there is some form of guarantee to protect private sector parties for some of the risks that they are being forced to take on. I recall working on a Lagos State transaction where it was a huge PPP project, and the state agreed then, and that was many years ago, agreed to actually provide revenue guarantees such that if there were no, because we didn't have data on the uptake by the public for that service, and the state actually agreed to provide revenue guarantees. In today's legal regime, the state is actually prohibited under its own laws from providing such support, and that does create an imbalance in the negotiations. And then when you layer on the constitutional issues, I'll give you an example. I would say about 15 years ago, when you're negotiating a project that transcends between federal and state boundaries, you see the states saying, okay, you know what, we will take on the risk of ensuring the federal government permits and regulations and approvals are given. Today, the state governments will just not touch that. They say, we have no control over the federal government, and that risk is passed on to the private sector party to undertake such risk, and that is another huge imbalance that we see in these projects.
So it sounds like the responsibility is being passed from somebody who feels like they don't have much control over that risk to somebody who has even less control.
Correct, yes. Correct.
So it's just, the question is, are we trying to avoid risks or manage them? And it sounds like there's just an avoidance going on there.
A lot of conversations have been had around managing the risks, the more collaborative types of contracts and arrangements that are being done as well. And we do tend to advise that, you need to ensure that you have local co-investors, have local venture parties who understand the lay of the land, they understand the regulatory regimes, they have connections within the governmental agencies, and they are able to provide support in those core public sector risk issues that the state has tried to push down on the private sector party.
Great, thanks. So, we'll get back to you, Stefan. I mean, what insights do you have to share about the ramifications of getting risk allocation wrong in contracts?
Hello. Yeah, so now with gremlins out of the line, we'll try to do this session. So the Crux Insight report is an HK research. It's an academic paper that has been cited by the UK government. It's been cited in numerous instances. And we touched on this last year, as I was saying, when I was in this conference as well. But I thought it's worth it to touch on it today because it talks to risk allocation and the practical consequences of it. So it'll be, for those of you who are new or weren't here last year, it'll be new. For those of you who were here, it's an updated edition. So we issued the latest Insight report in end of 2024. So if we just go to the first slide, where do I click here? So just to give you an idea of the type of data that the Crux Insight report takes on board, it's based on data, real data that HK has been involved in our claims business. So from 2018 or so, the first Crux report was issued, and it's been updated every year. So basically, it touches on 2,000 projects, 994 EOT years claimed, 107 countries. So it's, by all means, it takes into account a vast amount of information. So if we touch on first the global perspective, the Crux Insight, it has a global perspective. It also goes regionally. It goes into industries, sub-industries, and so on. So it's quite complete. So just to touch on globally where we are in terms of claims, and I'll touch on Africa in a moment. You can see here that the top causes of claims and disputes are, firstly, change in scope. The design was incorrect. The design information was issued late. And there's a whole rafter of issues there, and this in itself would probably be subject for a session. But we'll keep away from that for now.
Just to jump in there, Stefan, so I guess you could label those 10 items as risks, I guess, just to tie it to this topic today.
Exactly. From a global perspective, these are the risks that we see. And we'll cross over to Africa now and see in Africa and spend a bit more time there. So the one thing that I thought was interesting to highlight was that for most projects, you see that it's in inverted commas, the consequences of the haste to start and press on with works plays out in various ways across sectors, but are most commonly negative. So what we find is that in most cases, there's this the go slow to go fast approach is forgotten. Projects go fast from the beginning, and then they're not able to catch up with that haste later on in the project. And that we see is causing a lot of problems throughout the claims landscape. So this was globally, and then if we go to Africa, I'll leave you with this headline to start with. It says that the toll of claims and disputes, both in time and financial impacts, is heavier in Africa than in any other region globally. This is, again, subject for a whole separate session to unpack the statement, but it's certainly something that is eye-catching, at least. This was in our previous report, but it's still relevant today. So going to the last slide. This is a summary of claims and disputes in Africa. So you've got in gold the African statistics and in blue the rest of the world. So you can see that regarding extensions of time, there's perhaps not such a big difference between Africa and the rest of the world. It's 76 versus 66%. When it comes to cost claimed, though, there we do see a relevant difference, where in Africa, as a percentage of total capex value, the 60% of additional costs claimed versus 32% in the rest of the world. So that certainly is something worth spending a moment on to think about, as in what are the consequences of this, what can be done to avoid it, and it boils down to risk allocation. In terms of the top causes of claims and disputes, I've got a few listed here in the bottom. You've got change in scope. That is, Africa is roughly on board with the rest of the world in respect of change of scope. I mean, I think that is understandable. Variations, changes during project execution. They basically change the nature of what was negotiated, and that results in claims, and as I said, both in Africa and the rest of the world. Now, the next one is where we find a big difference. Access to site was later restricted. I mean, I can say from my perspective, having been involved in a lot of claim situations in Africa, in South Africa in particular, this rings very true. This is something that I can recognize very much. You've got mega projects with multi-contractors, and the moment that one is delayed, it has a knock-on effect on the next ones, and that boils down into that significant difference. Design was incomplete. Talks to the go slow to go fast issue before, where we're trying to be as fast as possible in the pre-contract phase, but then get caught up in the contract phase because there are issues missing. So there are multiple issues, and I think the Crux report was on most tables yesterday. So I encourage you to have a look. It's a very interesting read. There's a lot of more information about claims and the differences between Africa and other continents. Thank you.
Thanks, Stefan. And I just want to draw a link between the fourth set of bars there, the cash flow and payment issues, which I think was the subject of panel 2 yesterday. And it was acknowledged that that's not unique to Africa, but from what we see at HKA, I guess it's an increased risk issue in Africa compared to other places in the world.
Yeah, absolutely. And then, I mean, the fact that in Africa there's no statutory adjudication in respect of payment issues, that is, you know, that potentially is one of the reasons that is there.
So, Diogo, and once again, just to refer to, before I go to you with a question, just to refer, the cost claim circles at the top there, obviously something's a little bit different in Africa, whether it's the power imbalance or whether it's other factors which are leading contractors to, or creating an increase in challenges for contractors. So, I mean, do you think the root cause is technical, cultural, institutional, or a mix of all of the above? Why do projects in Africa, you know, have those percentages and statistics which are higher than other places?
Battery. Thank you. So, nice question. Thank you. I would say that the three, not all at the same level, but the three of all compete to the result. I don't want to repeat myself, but I really think that in the beginning of most of the problems is this mismatch during contract negotiation and then contract implementation that leads to a number of contracts, of problems further ahead. Because usually the overhead that contractors have in Africa is above the average also on the rest of the world, because risks are higher. That's also very true. But when the risk materializes, then there is a problem. Or even when there is contract changes, or when it is needed to renegotiate, or a change order, or a variation, or even lack of payment, here the problems are quite different, because the employer usually tends to think, no, I have nothing to do with this. I have pushed back all the risks, so all I have to do is pay. This is the only thing I have to do. And it's not that. I think that this has a cultural and institutional problem, both of them, and leads also to the fact that during contract execution, there is also a very quite proportional deviation between the technical capacity of public authorities and the contractor. And which is the best way of a public administration to defend itself? Is to say no. It's always defended. I say no, if he wants, he goes to court. I have heard this many, many times. I understand, but no. If you go to court and I have something that condemns me to pay or to prorogate, I will do without any problem, but I will not take the decision. And this links with something that we have discussed here also this morning. That's the corruption issue. And not the corruption itself that I wouldn't like to touch, but the perception of corruption, which is a different concept. I don't know if corruption in Africa is much higher than in Latin America or in Asia, to be honest, or even in Europe. I don't know. But I do know that the perception of corruption is much higher. That is clear. So, as the perception of corruption is much higher, this tends to have public defendants also more defensive, because tomorrow they will be asked, you granted this, you made that variation, you paid, you agreed with that change, you agreed with that request, maybe you were paid because of that. And this also leads to a very difficult, and this, from my experience, the cultural problem. It is much more difficult to execute contracts in most countries of Africa than it is on other regions. That is clear. And that is because of this perception. No one wants to take the responsibility. But it's coming down to Europe, to be honest. It's the same thing, to be honest. So I think all the three, and they mango, to be clear. I don't think that because institutional deficits led to cultural issues, and this brings to a great difficulty in executing this kind of contracts. And then maybe, I don't know the numbers, but maybe this is because on other regions it is easier to have a negotiated solution, because there will be claims also, but it is easier to get to a negotiated solution.
If I can, just on that, and on the previous panel, or the panel this morning that talked on corruption, this report, the causes of claims, you know, they are the whitewashed causes of claims. We don't know to what extent there is corruption underlying these causes of claims. You know, we've been involved in South Africa with the SIU, with the Special Investigation Unit, for 4 or 5 years, where we've been working together closely in order to identify and quantify the cost of corruption in South Africa. So we're dealing with a parastatal enterprise in South Africa, and we're there with a number of people, a very substantial number of people, and we're going through all the different packages and identifying and quantifying the corruption that has happened, or irregular payments that have happened. The SIU then comes in and defines, you know, what exactly is corruption. So that's been a very interesting process that is still ongoing as we speak. But yeah, and it has borne fruit, as in we have, as in one of the parts of what we do then is also aim for the recovery of those unduly paid funds to contractors. And in that respect, we've been involved in the highest recovery of funds due to corruption in South Africa. So it was in respect of one of the big power projects. And yeah, it's over R1 billion that we recovered for the South African government.
Tim, if I can share one sentence, just the problem with corruption, from my point of view, and I have absolutely no data to support this, is just my own perception also, is that there is, of course, much more corruption than it is discovered, but also much less corruption than what people think there is. And this mismatch originates this perception of corruption that it is not totally accurate.
Thanks. Yeah, so before we move on to a go-go for some solutions, perhaps, or some things, some innovations you've seen, I'm just going to allow John to just comment with your transactional experience. I mean, did you want to add to any of the comments that was just made by Diogo?
Hi. Yeah, thanks, Tim. Well, I think I just wanted to take us back to before the contract signed again, and to just think a little bit more about, I mean, and no doubt corruption is out there, but there's lots of things actually that mean that projects take a very long time, sometimes years, to get from the initial procurement up to signing. And I've just got a few things that I've got here in front of me that are the key areas reasons that happens. Number one, often the ambition is huge. Often we're trying to do massive pieces of infrastructure in Africa that have not been done in that particular country or region before. You're trying to do one-off projects, and often at some level, at government level, developer level, contractor level, lender level, you haven't got the same experience as you may have in other parts of the world. So you're trying to do some amazing things here. Number two, the interaction with government is really interesting. It's often almost always there's a level of government procurement involved, but often I see government almost kind of trips over itself. You've got part of government that wants the project to go ahead and is focused on that, but then you've got other parts of government next to it, beside it, within even the same departments that have got different ambitions for the particular project. They don't necessarily want to destroy it, but they want it done in a different way. And that plays out during the procurement. Number three, I think in Africa, more than anywhere else in the world, the political cycle in individual countries has a massive impact on the delivery of close for projects. Often I'm sort of scratching my head and clients are saying, well, this isn't going to happen for 2 years now. And I'm saying, well, why? Well, we've got elections in 2 years. Nothing's going to happen in the 2 years before elections. It'll be after the elections that will kickstart the next round of infrastructure development. Number four, there is often massive, unanticipated project-on-project risk. We're building a power station. There's a plan to build the grid next to it, but the plan to build the grid proves to be shakier for whatever reason than the plan to build the power station. You're planning to build the road, but in order to build a new toll road, you need to shut the existing road, which initially seems like the obvious thing to do, but politically, as the project proceeds, becomes more and more unacceptable. Number five, employers under-prepare for their projects. And that's possibly overcritical because there's so much to do from an employer side in the tender process, in the project preparation process. It's got to engage with government, it's got to engage with local communities, and I can't overemphasize how many times the failure to engage with local communities has resulted in projects failing. It's got to engage with the contractor market, and the comments we're hearing from my colleagues here that the contractors don't like the risk being passed on to them. Well, there's an opportunity for employers to go to market, to listen to how contractors would like to engage contractually before they go out to tender. And then it's got to go, the employers have got to go out with a sensible tender. They've got to think how many bidders they're trying to engage, how they're going to compete those bidders, how the employers are allowed to leverage their positions and to try and get the best deal that they can get, because they are, after all, despite passing all the risk on the contractor, they are, of course, also proposing to pay the contractor for the acceptance of that risk. So, number six, once the employer's gone out to market, once he's got his responses from the contractors that have chosen to bid, that have seen the terms, looked at them, thought about them, chosen to bid for the terms, you're in that sort of super negotiation phase, round the table, trying to do the deal with the contractors. In order to be able to get to all these claims positions, you've obviously got to do the deal and sign the contract. And I'd love the contracts. We spend all this time, years sometimes, negotiating. I'd love them to be perfect, especially my ones. But I hate to say this, they never are. They're always full of compromises because that was the best we could do to get the deal done.
And you've also got Diogo and his team there. You said the day before signing the contract's the most important day, and that's where the bulldozer comes out and pushes all the risk in one direction.
Well, I'd say two things there. I often find, if I may say so, that contractors will play a very canny game and will refuse to take risk, knowing that the time pressure is on the employer more and more as the time goes by to get the deal done. So contractors know their game, possibly more than the employers do. So it's often, the vocabulary that's always rolled out is that's not bankable, that's not market. And that's effectively what we spend our time in all these negotiations talking about. Okay, what's bankability in this context? What's bankability in Kenya in 2025? How does it vary from what we did in Nigeria 10 years ago? Why should it in fact be the same? What's changed? That's what we go through. That's the negotiations we apply. And if both sides want a deal to be done, that is the basis on which a deal is eventually done, sometimes in very grinding form. And last one, and then I'll hand it over, is in order to get any of these contracts signed, you need a magic ingredient. And it always amazes me, and I get really struggle sometimes as to why that magic ingredient sometimes just isn't there. And I see clients and other parties just almost banging their heads against the wall to try to find where that magic ingredient has gone. And what that magic ingredient is momentum. To get these deals done, they're massively complicated. There's things coming at you from all sorts of different angles. You've got to have a capable and a very, very driven team at the centre that is absolutely determined to solve the multiple problems that are being posed and to get it done and to get it done quickly. Because the more you let it drag, or the more sometimes you can't help it, the more it happens to drag, the more you lose momentum and the more you increase the risk that you never get there.
Thanks. And go ahead, please.
On the cyclical nature, of the administrations, we usually say on my team that really with all the best efforts in the world, you have a 4-year cycle, because every 4 years we have elections. But even when there's a continuum, let's say it's the same party, just a change in administration, so you're expecting that the policies will continue forward. Sometimes that's just not the case. So in Nigeria, we have the road tax infrastructure credit, under which some really impressive pieces of infrastructure has been delivered. Started in the prior administration, same party, new government, and immediately the new government came in, signaled that maybe we won't go on with this infrastructure tax credit. It's reducing tax revenue because corporates are able to get a tax credit for infrastructure delivered. That immediately throws all the projects that are ongoing in a tailspin. Nobody knows if the government's going to wake up the next day and say, this is cancelled, everybody go home. Then you have a situation where you even have a new head in the ministry appointed. He wants to take different projects in a different way, or he wants to change certain materials, specifications within contracts that have already been agreed. So we are constantly in this variation loop. Time is being lost. Inflation and devaluation is eating even more into project pricing, which invariably leads to more tax claims, more or less almost defeating the original purpose. So it is really a clear risk for the private sector.
And the challenge, if I may say so, and this is sometimes really, really hard to pull off, but as an employer, you've got to be investing on both sides of the political spectrum. And sometimes that's just simply impossible, but that's always, you need possibly both sides of politics to be buying into your project.
It has to be in your strategy if you want to have a long-term stay, and viability in the economy.
I have a client that usually says there's nothing more expensive in construction than changing ideas. And the government changes ideas from 4 to 4 years at the most, because sometimes even between the same government, the ministry goes out and they change ideas. And this is a big, big problem.
Thanks. So we're going to try and change the speed a little bit from the problems, which I think we've over the last 2 days talked to death. And I'm going to open it to the panel, perhaps starting with you, Agogo, of any recent innovations or solutions you've found, whether it be financial risk or other commercial risks, that perhaps we can take away from today and think about.
I think the challenges in the economy and in the jurisdiction really makes us more creative. Investors are more creative, project owners are more creative, even the governments as well try to be more creative. When we see all kinds of schemes between the funding parties, lenders, insurers, sponsors, and on the government side trying to de-risk these projects to ensure that projects and the infrastructure are delivered. So we have on the credit guarantee side, there are some companies that are doing really good work. I could name InfraCredit. What they try to do is de-risk the credit risk of these projects, and they also really crucially for Nigeria with the foreign currency crunch that we're just about crawling out of, they are able to ensure that the credit-backed guarantees give access to Naira funding, which is important for infrastructure that is being built for really the use of the population who have seen purchasing power more or less just deflated beyond imagination. I think another one is the SDIP, the Sustainable Development Investment Partners. All of these provide products and credit guarantee that make the projects more attractive. For instance, what InfraCredit does is that they give access to the much needed pension funds. Nigeria has a very rich pension fund, and the law prohibits pension funds from being used for more risky projects. For what InfraCredit does with the credit guarantee that it provides, de-risk it such that pension funds are able to be used for these projects. And that really provides long-term capital, really longer than the banks are able to provide. And I also work on some projects where we have the Gates Foundation. The Gates Foundation has a capital that also provides patient capital into these projects. Again, longer term, we're talking in 5, 7, 10 years, which the banks are usually reluctant to provide. So all of these blended credit type facilities where you have a bit of the lending, you have the patient capital, you have the multilateral capital, they all help to provide access to much needed financing, and it's really critical for these projects. And we also see more of an uptake on contractor financing. We've seen very innovative structures being built around contractor financing, contractor equity. You want to work with contractors who know the market. I mean, I'm talking about the Julius Bergers of this world. They know the market. They've done long-term projects in the market. They understand the lay of the land, and they are able to work collaboratively with project sponsors and employers to manage the risk. And sometimes it's also like putting some skin in the game as well and taking some equity or providing funding towards projects. And all of these help towards managing credit risk.
Thank you. I mean, that skin in the game point, I think, and that's some tangible action that a financier can make to actually be collaborative. That word gets thrown around quite a bit.
You know, I'll tell you, I'm actually in one project now where a whole almost new city is going to be created offshore Lagos. And the very clever thing that the contract sponsor has done is to rely on, first of all, local equity. So before we even have a deal signed with Lagos State Government, what we have now is a letter of award. We are already oversubscribed on the equity side because this is a very exciting project. I think it's Ayodele that said yesterday about bankability. When the project makes sense, there's actually funding locally. You just need to ensure that the project is attractive enough to attract such equity. So the plan for this project is, first of all, use equity funding, local equity funding. Then in the secondary stage, we go into the international markets.
Thank you. So the bad news is we seem to have got too excited and we're slowly running out of time. The good news is that that's just 5 more minutes of us. Hopefully you've got some questions for us, which I will open up the floor shortly. I'm just going to spend that 5 minutes, perhaps one quick question each to each of you. Stefan, with your solutions hat on, after the project is being contracted, what can one do to manage risk?
Well, I think that it is very important, the post-signature of the contract, the risk allocation management, because that's when the rubber hits the floor, right? So it's all about being proactive, not being reactive at all, because if you're reactive on project risk and risk allocation, you're forever chasing trying to fix the risk that has materialized. So you need to be proactive. That's the first one, I think. Also, some other thoughts is often I see that in project execution, they have a different team than the one in project tendering. So you lose a whole lot of information, a whole lot of risk understanding in execution. So from my perspective, you should have the same team all around. Worst case, you keep 1 or 2 people at least who have been in project tendering to continue through project execution. Or at the very, very least, at least you have a good session of 2-3 days where the tendering team and the execution team have a discussion as to what the risk allocation is and where we're going with that. So basically, it's like you can't leave it to chance. The risk allocation needs to be managed throughout the lifetime of the project. It's not something that you can look at in the beginning and say, well, these are my risks and off I go. It is something that you need to be monitoring, dealing with as you go on, as the project goes on, because the risks also evolve. They don't stay the same. They don't stay static. So, you need to be on top of it the whole time. So within the very short time I have, that's what I can give.
No, thank you. So, Diogo, just quickly, if you were king for a day, which would be fun, in a perfect world, how would you design or redesign a risk balance contract? And then I might just get Ogogo for you to sort of comment from an owner's perspective, and for you, John, just to close out perhaps from a lawyer's perspective of how owners and lawyers can buy into that mindset.
I would love to be king for a day. And it's not because I'm a lawyer, but if I were king for a day, I would say that both parties would have to instruct good lawyers in order to reach an agreement. To be honest, there is nothing more difficult than to negotiate with someone that has never done that before, is always pulling back just because he doesn't know what he's doing. And this happens a lot, really a lot. And then, this being said, I think that it should be common ground that some risks should bear with the employer and that some risks should bear with the contractor. And this should be common ground. For instance, we have a railway project. It's a 100 kilometers railway project where the archaeological risk has been shifted for the contractor. I hope, God, that they never find anything. Because if they do, I'm sure that the contractor will say, no, not this kind of archaeological risk that I bear. I bear it if I found something little, not if I found an entire city or something like that. So I think that some risks, exchange risk, at least part, site access, land acquisition, this should be common grounds. It has, and on the contractor side, also quality, management of subcontractors, delivering the project. Sometimes we forget that the most relevant commitment that the contractor does is that he will deliver the project that he was employed to do. Because sometimes contractors also want to deliver something a little bit different than they were employed to do. And that's true. That's
cut corners.
Am I owner?
Yes.
I would look at the project really more from a collaborative point of view, in the sense that as owner, I want to work both with all stakeholders, consultants, the government party, all the host communities that the project will be serving, to ensure that everybody's interest is taken into consideration. I would definitely be looking at ensuring that I understand the framework, legal framework, really important, getting the best consultants and contractors and subcontractors in place. I'll really also take a good look at insurance. I want to ensure that there is some pricing really benefits and reductions to be had around insurance. Maybe do the owner controlled insurance scheme, and also just to ensure that the contract is fair and equitable. I wouldn't want to take on more risk really than I should ordinarily take up, and I would like to build flexibility into the contract. Maybe have regular reviews on the risk allocation to see whether there can be room for moving risk or reducing or even sharing risk as the contract evolves, because there are different phases. You're doing the conceptualization, design, construction, operational. So the risks are not static, and that's something I'll really be paying attention to.
Great. It sounds like you'd be a very proactive employer or owner, so that's, I think we could all agree, more of those would be welcome. John.
Hi. You know, when I first started doing contractual negotiations, you'd go into a room and it would always be, it's us and it's them. It's our side and it's the other side. But the more I've done it, the more I found myself feeling that if there's a failure to get that contract signed, it is the responsibility of all those people in the room, i.e., it is a single team in the room that needs to work together as a team to get the contract signed. Now, sometimes it takes months for the people in the room to realise that they are a single team. And if I were king for the day, what I think I would encourage would be everybody that's going to be in the room, going out for dinner, spending a bit of social time together, getting to know each other, getting to understand each other, getting to find out on a human basis how they can get to like each other, to enable them to quickly work together to overcome what are often some very, very substantial problems to ever there being a chance that the contract is ever going to be signed. So Teams has a role, but don't try and do it all on Teams. You've got to meet up, and then you can go back to Teams before you meet up again.
Thank you. And I'm sure Stefan would say that that mindset and that attitude shouldn't stop after the contract's signed as well, and hopefully continues through the delivery of the project. So thank you.
Sadly, sometimes those contracts are not signed. You have great teams, everybody gets along, you sat in rooms or hotel meeting rooms for months and months on end. I tell you, about 12, 13 years ago, I worked on this project. Almost 5 years of my life, constant traveling. We all loved each other. Till today, we are really good friends, but the contract was never signed. 5 years, $2 billion.
Well, in that case, I've been there as well.
So it
sadly,
happens, really.
But I've also, fortunately, signed quite a few contracts too. But I should probably add, in becoming friends, you cannot lose the rigour. You cannot do a soft deal. You cannot let things slip under the table. So in being a team, you've got to maintain your professionalism, and that's the balance. That's the trick. That's what you're paying your advisors for, and that's what they should be delivering.
It helps for sure, but then government focus changes and everybody goes home.
Fair point.
So the perfect project's the one that was never signed and delivered. It's a nice, light-hearted note to finish on. So, yeah, any questions before we finish up? I'm not sure how long we've got for questions, but it'd be nice to have a couple.
Hi, good afternoon, everyone. Ayodele Faboya from Lagos, Banwani Gudalu. So my question relates to, and thank you first of all to the panel, fantastic conversation. My question relates to the point that was made around the skin in the game for contractors. And that particularly hit me because it's a point I'm really passionate about. I think that, you know, having contractors or stakeholders, counterparties that bring some value to the project is very important. That may be the turning point for bankability of some of our projects in Africa. And indeed, not even just about the ability to put in equity, but sometimes just the access that some of those contractors can bring to export credit agencies or to insurance that then allows them to give you more favorable terms. And so when you look at those types of things, you think an EPCF, or indeed an EPCF O&M, looks like the ideal thing. When you think about the risks that have been raised today, interface risk already is a major risk. That takes care of it. It takes care of the risks that have been raised around acceleration of the project, because you imagine that if somebody is managing the entire life of the project, then it's accelerated. So is this something that, as Africans, we should be looking to more as a structure, that EPCF model or the EPCF OM model? Or is this idealistic, given the types of challenges and risks that we are facing in the context of Africa? Is it idealistic to be looking at that type of model, or should we be structuring more along those types of models rather than your traditional PPP models? That's my question.
Hi, that's a very good question, and I think it's worth considering, even though my personal view, to be honest, is that I think it's slightly idealistic. I think those structures thrive really in stable environment. You have regulatory stability, price stability, environment, and due process, and it may be harder really to adopt those as the standard structures. But importing aspects of those into current PPP structures, I think, would be useful, because right now the traditional PPP structures that we are using aren't doing so great.
I'd just add to that that having spent many years trying to do PPP in Africa in various different forms, what's meant by PPP in Africa is a very, very broad set of things. But on the pure PPP, where there's a sort of full pass down of the project agreement, those projects are I definitely agree, they take forever to achieve in Africa, and they're really difficult to achieve. And they've only been achieved elsewhere, really, in a repetitive way, where there's been a massive pipeline of those projects. The early ones have always been really difficult. What I just say about acceleration, though, and insurance, whatever you're doing, whether you're doing PPP, EPCF, Yellow Book FIDIC, any of it, you or somebody will end up with the legal to insurance, the legal to contractor analysis of those points. And you'll sit in a meeting, you often go through the meeting with saying, that's an insurance point, that's an insurance point, let the insurers deal with it. And we pull the insurers in next Tuesday, and they shrug their shoulders and say, that's not an insurance point, that's a contractual point. And then you have to spend the time working out what is it on those insurances that you need to deal with as construction contract lawyers. And on acceleration, which is always a very difficult point, there's often a long debate with the contractors as to how much acceleration risk they're going to bear, particularly if they're bearing liquidated damages for delay anyway. Why should they be obliged to accelerate as well? It was only this week I had with a very large turbine supplier, well, we're not taking acceleration risk. If we're late, we'll just pay liquidated damages. That's early involvement, that's project management, that's the employer wanting to have the right to accelerate if need be at the contractor's cost. And then that's an argument around the table as to whether that is an appropriate clause for the contractor to have to sign up to or not. And I would say, broadly, sometimes they do, and sometimes they don't.
All right. Unfortunately, we are totally out of time. And I know we have lots of questions. So we'll try to create an opportunity where you can ask those questions directly. So please forgive me, because I'd like to bring this to a close at this point. But thank you so much, Tim and your team. And I know it's for our frustration both that we can't continue with this. So let's give them a round of applause for that conversation. I would like to invite Mr. Sean Gibbs, if you could come up and just help me present a plaque of appreciation to my people before they step down. So we have one little session that will happen right after this, and that will be just to try and sum up a lot of the discussion that we've had here. And we've had a team of rapporteurs who've been capturing this so that it's useful for you, even as you head out and back to your areas of work, you have something that guides you on the next step. But Mr. Sean Gibbs, if you come. Would you like to be upstanding for your picture, please? Big smiles. Excellent. Firstly, let me just say a big thank you to the chair of this session, Mr. Timothy Hawken, who's a partner at HKA South Africa, for running this session. Really appreciate your time and efforts for doing this. Thank you so much. Also special thanks to Mr. John Woodley, who's a partner at Pinsent & Masons in the UK, for being part of this conversation. Thank you, Diogo Duarte de Campos, partner at PLMJ Lisbon, Portugal, for sharing your thoughts with us. Also, thank you to Mr. Stefan Brill, who's a partner at HKA South Africa and Spain, for being part of this. Really appreciate your time. And lastly, the lady in the panel, Madame Ogogo Makinde, who is a partner at Aluko Oyebode Airline, Nigeria. Thank you so much. Excellent. Thank you so much, ladies and gentlemen. If we could just give a round of applause to our panel. Right. So, ladies and gentlemen, we've had tremendous submissions made here. We've had excellent contributions, and speakers have shared from their experience and the unique work that they're doing in their markets. And our hope was that in the space of these 2 days, we'd be able to have a clear picture of the challenges that we face as a construction industry on the continent, but more importantly, to address some of them. And I'd like to say a big thank you to all of us for sharing our thoughts candidly, for sharing our experience, and more importantly, for our time, for being here. So at this point, I'd like us to have a moment where we get a bit of action points in answering the question of where do we go from here, because I think that's a question in the minds of most of the people here, and that will help us in knowing what do we tackle first when we move. And to guide us through this, it is my pleasure to bring on stage Ms. Yolanda Walker, who will give us the next steps. Welcome.
Hello. Hi, everybody. Thank you. I'm not actually here to give you action points. Unfortunately, our program doesn't allow for us to have this discussion, but we should still have this discussion at some point. There was actually half an hour scheduled for this, but we have other things, more important things to do, and that is to network later. I would like to just conclude and wrap up actually, and just to say what a fantastic program it has been. There's been so much quality content. We've heard from real experts in their fields, and the theme this year, the future of construction in Africa, has in some way united us all that's in this room and made efforts to be here. We've covered so many topics which are key to the future of construction in Africa, from payment issues to dealing with corruption, improving the bankability of projects, and even management of risk. One of our key objectives as Africa Construction Law really is to engage with capacity building on the continent and training, and the last 2 days have done exactly that. Another objective is to provide a platform for construction industry professionals to network, and that's what brings me on to this evening. We look forward to welcoming you all back at 7 p.m. here, ready to network the African way. The dress code is elegance meets African heritage. We will also be celebrating our winners of the ACL Awards. And then finally, just to conclude, I'd just like to thank all of our speakers. I'd like to thank all of our sponsors, and I'd like to thank you all for joining us here in Nairobi for the ACL's 5th annual conference. We really do hope you will all return next year. The location is yet to be announced, so do watch out for that. If you have any questions about the ACL, if you want to get more involved, if you've got any ideas, and as I said, we do want to really have those action points. If you've got those, please do email us at info@africaconstructionlaw.com. Thank you. See you all later.